Welcome to U.S. Immigration TV. I have some breaking news about birthright citizenship. So let's back up a little. When Trump first took office in January 2025, he immediately signed an executive order restricting birthright citizenship of children born in the U.S. Under that executive order, a child born after February 2025 would be considered a U.S. citizen at birth only if at least one parent was either a U.S. citizen or a lawful permanent resident or green card holder. So as a result, children born to parents who are out of status or were in the U.S. on a temporary non-immigrant visa such as a tourist visa, a student visa, a temporary working visa, H-1B, would not be U.S. citizens at birth. Now, almost immediately after this executive order was signed, there were legal challenges, there were stays, and there were injunctions blocking the enforcement of that executive order. So here is the breaking news. Now, the U.S. Supreme Court has decided to take up the case and decide the constitutionality of Trump's executive order on birthright citizenship, and more importantly, whether the 14th Amendment to the U.S. Constitution provides for U.S. citizenship to children born in the U.S. to parents who were not U.S. citizens or lawful permanent residents, but instead the parents were out of status or in non-immigrant status at the time of the child's birth. A decision is expected by June of 2026. Now, first, and this is very important to all of you out there, I want to emphasize that the executive order would apply only to children born 30 days after the executive order was signed, or February 2025, and not to children born before that time. So I know that there are many parents out there who are out of status and have been patiently and eagerly waiting for their U.S. citizen child to reach 21 so the child can petition them. So now the parents are worried that whether the child will now be stripped of U.S. citizenship. I want to assure you that is not the case. Relax. If your child was born before the effective date of that executive order or before February of 2025, that child will remain a U.S. citizen regardless of how the U.S. Supreme Court ultimately rules. So in this video, I'm going to go back and explain the background, the history, and the issues involved in this very important controversy. In case you're at some kind of party or you overhear something, I want to set the record straight so that you'll be informed. First of all, the 14th Amendment to the U.S. Constitution, which was enacted right after the Civil War in the 1860s, states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So that's the 14th Amendment. Trump argues that the 14th Amendment was intended to extend citizenship only to the children of formerly enslaved people, and it has been wrongly interpreted to apply to children of illegal aliens and non-immigrants. In other words, the 14th Amendment came right after the Civil War, ending slavery, so the question was, what's the status of the former slaves and their children? The 14th Amendment said the kids are going to be U.S. citizens. Trump further argues that the 14th Amendment grants birthright citizenship to children born in the U.S. only if the parents are subject to the jurisdiction thereof. Remember, that's the phrase in the 14th Amendment. Well, historically, that phrase was interpreted to refer to children of diplomats who are not subject to U.S. jurisdiction. In fact, if a congen of another embassy is here in the US and they have a child, that child is not a US citizen, green card holder. So Trump argues that people who are out of status or on non-immigrant visas are not subject to US jurisdiction in the sense that they still owe their allegiance and loyalty to their original country. So therefore, the 14th Amendment birthright citizenship does not apply to their children. There was an 1898 Supreme Court case, it was called Wong Kim Ark, that people are citing to challenge Trump's interpretation of the 14th Amendment. In that case, a person born in the US to Chinese parents, so therefore the parents were not former slaves, was considered to be a US citizen at birth under the 14th Amendment. So therefore, the 14th Amendment does not apply just to children of former slaves, and people argue that that 1898 case has already resolved the issue on birthright citizenship. However, that 1898 Supreme Court case emphasized the fact that the Chinese parents were long-time residents of the US or permanent residents, which really is part of Trump's executive order, where he provided that children of lawful permanent residents are also considered US citizens at birth, such that Trump argues his executive order is in conformance with the 1898 case. Therefore, the issues and arguments really are not that clear-cut. Trump's arguments may have some merit. Furthermore, just because the US Supreme Court has decided an issue or case one way does not mean that they will not overrule or overturn a previous case. For example, we all know that the US Supreme Court overruled Roe versus Wade on abortion. That was a long time case. People thought that that case would never be overruled, but it was. And they also overruled, famously, another long-standing case that promoted separate but equal facilities and the treatment of blacks and whites, and in fact promoted racial segregation, which fortunately was overturned in Brown versus Board of Education. But the point being is that the US Supreme Court, while following precedent decisions, which means old existing cases, they may sometimes overrule themselves. So for me, this is a fascinating case with far-reaching implications that could affect our country for decades to come, in that it may redefine who is a US citizen, effectively halting birthright citizenship unless the child's parent was a US citizen or green card holder when the child was born. I assure you that I will continue monitoring and reporting to you on developments on this and other important immigration issues and developments. Therefore, please make sure to hit that subscribe button right now. Subscribe, like, and of course, share this video, especially if you have family or friends who have children born in the US and they're watching and following the developments and are very nervous. This case, I wanted to explain to you in plain English what the issues are, and most importantly, part of this video is to assure you, as parents of US citizens, that children born before February 2025 will continue to remain US citizens. And that's another point before I sign off. If you are out of status and you have a child who is 21 or about to be 21 years of age, I would recommend that you consult with an attorney before filing anything to make sure about the requirements, the eligibility, the type of documents necessary, and whether you are eligible to apply for your green card or adjust status in the US. Even if eligible, Trump is getting very, very tough in the screening and making sure that all the documents are included, all the forms are filled out correctly. You don't want to have a denial, especially if you're eligible. And an attorney can make sure you are eligible and package the case properly to greatly increase your chances of success. Well, I'm Michael Gurfinkel, and thank you for watching U.S. Immigration TV.